But counsel, so I guess one problem I'm having is just the analytical one. I mean, let's assume that we think you're right and that there's preemption. You still have to decide if you're saying that state law can't control, then some federal common law does. And Boyle, the conflict, you're right, it was different, but there were contractual terms. And so the court was very focused on the specific conflict between the contract that the helicopter design fulfilled and the state tort law. Here, if we say that because of the uniquely federal interest in waging war, state law can't operate, I take it what you're asking us to do is say, and then as the federal common law rule you should adopt, you should go look at the combatant activities exception in the Federal Tort Claims Act and extend it to contractors. So it seems like a very fancy way of just saying you should look at the Federal Tort Claims Act and extend it beyond its text to cover contractors.
So that is part of the argument that the combatant activities exception can be used as evidence of Congress's intent on the types of claims that would interfere with the military, just like the court used it in Boyle. I mean, it was the discretionary functions exception, but it was the same way that it used it. I think more fundamentally, where we see the conflict and why between, applying tort law or even a tort law claim as a matter of federal common law to combat operations on a foreign battlefield is we just think there's inherently a conflict between what the military needs of its soldiers and contractors of how they wage war and a duty to impose reasonable care for the protection of others.
So it's two-step. One is that state law can't operate, and then second, please adopt, as a matter of federal common law, an immunity for independent contractors.
We would consider it preemption. That would be the step if you went through Boyle.
Well, right. But I mean, it seems to me you're saying state law can't operate because this is a federal enclave that has to be governed exclusively by federal law because of the federal interest in the war-making power that states don't have. But then you still have to decide what rule operates. And you're saying, and the rule that should operate is one of immunity for contractors.
What the rule that would operate is that the court would leave this area of common law to Congress's control. Congress has legislated in this area. Congress can adopt rules and create causes of action. But in the absence of congressional action, yes, we would say a state law claim or a tort claim.
Why aren't you?
I'm sorry, could you finish that? In the absence of congressional action, what?
A tort law claim would not be allowed to proceed.
Counsel, that's sort